Good morning for all. Good evening for our speaker, Professor Surya Deva, our participants, and everyone who is watching us, wherever you are, welcome. It's a great pleasure and honor to learn from you today on the issue of the International Treaty on Business and Human Rights and Expected Outcomes. Professor, I must confess that your trajectory and the way that you see the challenges in the subject of the business and human rights has been an inspiration for me and my colleagues. My name is Victoria, and here as co-organizers, I have my colleagues Daniela and João, and also as debaters, Leticia and Gabriele. So just to briefly present our initiative through the webinars that we are organizing here in the University of São Paulo Business and Human Rights Working Group, coordinated by Professor Eduardo Sá Diniz, we seek to address the problems increased by the COVID-19, and in the last webinars, we had several considerations about the growing movement towards what we can call an standardization of the obligations towards businesses. And this scenario is quite evident in the international context. The mandate of the Intergovernmental Working Group set up in 2014 was to elaborate an international legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. So the draft really represents an important step in international law because it helps to overcome the classical reading of international law under which only states as sole full subjects of international law can bear international obligations. There has been, however, a big resistance against the treaty, creating direct human rights obligations for corporations, and many consider unrealistic and too radical, and others, for instance, have advocated for the inclusion of international corporate criminal liability for international crimes in the draft. And we know that the elaboration of an international instrument such as a treaty is something quite complex and involves the conciliation of different interests. And to present this challenge and the current status of discussions concerning business and human rights, we have the pleasure to hear from Professor Surya Deva concerning businesses and human rights. And he's professor at the School of Law of City University of Hong Kong and chair of the UN Working Group on Business and Human Rights, and also world reference in the field of human rights applied to business. We are so grateful for all of you that are joining us today at these webinars. You are also part of this initiative to bring the business and human rights field to discussions in order to propose improvements and reforms. Just to remind that all of our webinars are going to be recorded and available on YouTube. If you can stay until the end or want to recommend it to someone. And without further ado, Professor, after your presentation, we will open a quick panel for questions to involve our debaters and participants to bring their own remarks. Thank you so much.
Thank you very much, Victoria. I hope you can hear me. At the outset, I would like to thank the organizers for organizing this very interesting series of webinars and also inviting me to participate in this particular event. I personally believe that students at universities have a key role to play in the future of the globalization and how we are going to operate the society in future, which works for the benefit of everyone. So an initiative of this kind, which is student-led, I understand, is very remarkable. And I hope other universities, not just in that part of the world, but globally, take a similar footprint forward, because the students are definitely key players. They're, of course, future leaders. They can be lawyers, they can be academia, influencing policies. They could also be part of businesses. So as future leaders, of course, they have a role to play, but also they have a role to play in shaping the debate and the discussion around those particular issues. So I'm very excited that I'm able to join this particular initiative. Now, in these remarks, I would like to focus on 3 or 4 broad aspects about the treaty. I will start with the treaty context from my perspective. I will highlight how we should situate this discussion about the treaty that has been ongoing for about 7 years or so now. And then I will talk about the interface between the UN guiding principles and the treaty. And then I want to talk about what should be the way forward in terms of the content, the process, and perhaps I will finish with that, and I will welcome any questions and comments or any disagreements that you might have on this particular view. As some of you may know, I have been working in this field of business and human rights for about 20 years now. And one running thread of my research interest in this field is that we need to place rights and rights holders at the center of everything. And what I feel concerned increasingly is that in many situations, when we are developing these initiatives, whether these are soft standards or hard standards at the national level, at the regional level, or at the international level, we are not putting the rights and rights holders at the center of the process. So if you have seen my writings, I would say that is the running thread in my writings and argumentation. So I think you should situate my thoughts with which many scholars may not agree, but these are my thoughts informed by this overarching concern. So let me start with the context. As you should know that this treaty process is not happening for the first time. This is what I call the third high tide. So as in an ocean, we get low tides and high tide. And this is a process that has been going on for a while, the last 50 years. So this is a third attempt at the international level, in my view, to negotiate a binding instrument which can impose human rights obligations on businesses. Of course, there have been some differences in terms of the first initiative that is started in early 1970s, because that focused both on rights as well as obligations of transnational corporations. And the second high tide was the draft norms that were proposed in 2003, but again, both of these initiatives failed. Third initiative is the current one, which is ongoing for a while. So I think this third high tide is a periodic phenomena, I would say, shows that there is a demand. Because if there is no demand, there is no need. You will not have those tides again and again. So in my view, that is the context I would like to highlight, that from the perspective of the rights holders and the situation on the ground, there is definitely a continuous demand and appetite to get binding human rights obligations. Now, we can debate and disagree what should be the nature of these obligations, direct, indirect, how extensive, how narrow, the question of liability, civil liability or criminal liability or administrative sanctions. We can debate and disagree on those issues. These are details. But I think no one can deny, in my view, that there is this continuous demand on the part of a range of stakeholders about this instrument. At the same time, if I talk about this in terms of economics, supply has been missing. So demand is there, but there is no supply. So this is a very unfortunate situation, in my view, that so far we have not been able to agree on any hard international law instrument which imposes these obligations. This issue is not new. This has been going on for a while. So I think there is this, I would say, asymmetry or imbalance between the supply side of it and the demand side of it. So that is the other point that I would like to highlight. In my view, this supply, whether we get it or not, will depend upon many factors, and I would mention some of these during the presentation today. But I think one key element, in my view, is going to be European Union position going forward. And I think that European Union position may also be shaped by the proposed mandatory human rights due diligence legislation, a draft of which we expect to be released maybe sometime in coming months. So in my view, I'll be very candid, European Union is very crucial in addition to the other actors that are already part of this process. And in particular, I would say civil society actors are absolutely vital. And I explain in some of my writings that we should consider international law to be beyond state-centric going forward. I mean, not everyone agrees with this proposition, but in my view, international law cannot afford to remain state-centric. And I think it is already not state-centric because we have non-state actors like transnational corporations, which are shaping international law already. So if transnational corporations are able to write the rules of the game for us, and international law is being used by transnational corporations, whether it is part of WTO, whether it is part of international investment agreements, then why cannot we, other non-state actors, as academics, as international lawyers, can create rules of international law and enforce them, right? So I think that is something I would like to mention. The other point of context, and perhaps this is my last point of context that I would like to highlight, is that as you would know, this process, as well as the process, the first high tide was led by the Global South. But there is a difference. The 1970s process was also led by the Global South, but the objectives and consideration at that particular point of time were perhaps slightly different or significantly different as compared to the situation that we face in 21st century. In 1970s, the developing countries from the Global South were looking for to fix this imbalance of power. They wanted foreign investment, but they also wanted to ensure that these multinationals do not exploit the policy space, do not exploit the environment, do not interfere into the political processes and so on and so forth, right? So I think they wanted to impose these legally binding obligations on these transnational corporations. But at that particular point of time, the foreign investment flow was more or less one-dimensional. Multinationals were based in the global north and they were looking to invest in the global south. But that is not the case now because we have multinationals, quite a big multinationals from the global south, which are investing all over the world. So we have investment which is south to north, south-south as well, unlike the 1970s, where it was north to south for an investment trend. And I think that was the context within which we were trying to have those conversations about binding instrument. There is also another difference in my view. We did not have anything like a treaty alliance in the first initiative or the second initiative. And I think the fact that we have this treaty alliance, and I would in fact argue that without treaty alliance, the process would not have survived so far. That's my reading of it, okay? Again, people may have a different viewpoint, but my view is that if the process has survived, despite significant resistance on the part of the actors in the global north, one primary reason is the treaty alliance. And of course, when I say treaty alliance, of course, within treaty alliance also there are disagreements on certain positions and all that. But I think there is a broad consensus that we need some kind of an international binding instrument. I think that is there. The fact that we have these thousands of actors as part of treaty alliance from all over the world, that also reconfirms my earlier point that the international law should not be state-centric. So who is pushing for these norms? Civil society actors. And if you look at not just this process, but also if you look at the process within European Union about mandatory human rights due diligence, why do we have that initiative? Because of civil society in Europe. So what you can see is that it is very clear that if countries at the national level, at the regional level, or at the international level are being pushed to adopt binding rules, it is not a coincidence. It is the concerted efforts on the part of civil society actors. And I'm using this in a broad sense. In some places, it could be trade unions as well playing a role. And of course, there are increasing voices of investors and some companies also supporting those rules. But of course, primarily it is these actors which are very much there. My last point of difference that I would like to highlight, that why it is different to the third high tide, is the UN guiding principles. I mean, we may disagree, we may critique UN guiding principles. I've done it myself as an academic. But I think we should also appreciate the value and the difference that they bring. And I think in my view, the value and difference is that now even businesses are not publicly saying that we have no human rights responsibilities. So this acceptance, at least in public, in private companies are still doing the bad things, and you may argue that what had changed on the ground for the UN, what had changed on the ground for the rights holders, right? So I think that is a separate point. But what I'm saying is, in terms of should businesses have human rights responsibilities, I think that question is not part of the debate anymore. Almost everyone agrees that they should have human rights responsibilities. How do we turn those responsibilities into obligations? How do we enforce those obligations in practice? These are the pending questions, and that's why we are having this webinar. But I think that's why I have argued that the treaty should use the UN guiding principles as a springboard. They should build on it. I think that is the point I want to make. Now let me continue from this context and highlight a little bit the interface or the connection between the UN guiding principles and the treaty. My understanding is when the treaty process is started, and again, I welcome if there are any different views on this, but my understanding is when the treaty process is started around 2013, even before the resolution was adopted, perhaps the dominant objective of this treaty process was to supersede UN guiding principles. UN guiding principles are not good enough, they're voluntary, they're useless, they're not going to be followed. So let us replace UN guiding principles with something which is more binding and which is going to change something on the ground, because UN guiding principles are unlikely to change anything on the ground. My reading is that was the narrative, or that was the objective or the push. But I would say down the line, after a couple of years, there has been a shift. And the shift is of what I will call the mutually complementary relation between the UNGPs and the treaty. So I argue, and I have written about it, that we should not have this either or mindset. Because multinational corporations are very difficult regulatory targets. And because they are very difficult regulatory targets, we need to use everything possible rather than only one thing to regulate their behavior effectively. So instead of having this either or mindset, we should see a complementary relationship. And I would like to underline the relationship is not one-way complementary, it's a mutually reinforcing relationship. What do I mean by this? I mean by this is this, that if the treaty process can draw inspiration from the UN guiding principles text, it need not be copy and paste completely, but if you can draw inspiration from the text of the UN guiding principles, it may be easier to build consensus during negotiation because many states already agree on that text. So UN guiding principles will also help the treaty process, in my view. The other side of this coin is that the treaty will also help a better implementation of the UN guiding principles. So people who have a lot of commitment and faith in the UN guiding principles and they don't like the treaty process, I want to remind them that the UN guiding principles will also get better implemented if we have a treaty. And that's why I see this complementary relationship both ways. That's why we don't need to have any fear that, oh, what will happen to the national action plans? Because many countries have adopted, 25 countries have already adopted national action plans, right? So many people ask question, oh, we have invested so much in developing national action plans. So what will happen if we have a treaty? My response is, you need a national action plan anyway, even if you have a treaty, because the treaty has to be implemented at the national level. So this national action plan could in fact be comprehensive. In fact, one reason in my view why the national action plans are weak is because the states are merely looking at the UN guiding principles. They are not looking at the international treaties which are binding on them. And I think so this process of national action plan could also be a bridge between UN guiding principles and the treaty process. And I think that's how I see this complementary relationship between the two. The second point that I would like to highlight in terms of the interface is, and I think I already mentioned to that, is that often we claim that there is a very broad consensus, very wide broad consensus around the UN guiding principles, and this treaty process is going to fracture that consensus. I mean, people make that argument. I question this, that do we really have very strong and very broad and wide consensus around UN guiding principles? My feeling is that the consensus is perhaps wide, but it is very thin. It is not strong. Because if we had very strong consensus around the UN guiding principles, we would have made much more progress in the last 10 years in implementing the UN guiding principles. We don't need treaty for the sake of a treaty. We need treaty because the other initiatives are not working. That's why the demand. Go back to my point, right? So it's not that we are obsessed with the treaty. We like to put it in a museum, right? We are not obsessed with the treaty. We are arguing for a treaty because whatever else is there on the plate is not good enough. So we want to add another menu to the regulatory paradigm. In my view, that is what we should look at. So in my view, any actor, whether this is a state, a company, a civil society actor, an academic, anyone who takes the position that we should only support the UN guiding principles or we should only support the treaty is problematic. In my view, this is an indefensible position. Because if you support the UN guiding principles, you cannot oppose the treaty because the treaty is going to build on UN guiding principles. UN guiding principles are based on international law. And if this treaty is going to build on international law, it's an international law instrument, then how can you oppose the treaty if you're really serious about respecting human rights? Because this treaty is going to achieve the same objective. On the other hand, if you're really interested in preventing human rights abuses, and if you're really interested in ensuring access to remedy, why should you oppose the implementation of UN guiding principles? So I make this argument to people on the both sides of the camp. So I find these two camps problematic. Rather, the way forward is the middle path in which we try to have both UN guiding principles and the treaty process together, complementing each other, and we try to achieve this mutual complementary relationship between the two. Now, the third point that I want to highlight about this interface is that when we talk about complementary relationship, everyone is talking about it. But what does it really mean in practice? And in a recent paper that I have published in the Business and Human Rights Journal, I just put it in the chat box. I have argued, and I hope this paper is freely downloadable, so you should be able to download it, but otherwise let me know. So this paper deals with the larger questions of the interface between UN guiding principles and the treaty process and the mandatory due diligence and duty of care and all this. But I'll just focus today on the relationship of complementary relationship between the UNGPs and the treaty. What I've argued is that there can be two types of complementarity here. One is the basic and the second is ambitious. Basic complementarity of the relationship is when the treaty is being used merely to implement the UN guiding principles. And I think that is something we should be careful now. And I think that is in fact one of my messages today, that I see a possibility of some actors changing their position in future and becoming treaty supporters. But their objective of becoming a treaty supporter may also come with a risk, because they would like to push a treaty as per their own agenda. And I think we should be aware of this risk, because they may think that we need this treaty to implement better the UN guiding principles. We need this treaty to implement national action plans. That is what I call one-sided or a basic superficial complementarity between UN guiding principles and the treaty. In my view, we should go for more ambitious complementary relationship between the two. What does it mean? It means that the treaty process builds on the UN guiding principles. So UN guiding principles provide it as a starting point. But UN guiding principles do not provide the end point, which basically means that the treaty should go beyond the UN guiding principles, because nothing is perfect. UN guiding principles were not perfect 10 years ago. They are not perfect now. The treaty, whatever treaty we get, it will not be perfect. But we should try to frame an instrument which is more ambitious and which tries to fill some of the gaps that are becoming more and more visible in the UN guiding principles implementation or the text of the UN guiding principles. Let me give a couple of examples. UN guiding principles nowhere mention climate change, anywhere. They don't even talk about expressly environmental rights anywhere. I know, of course, we can make a connection between human rights and climate change. We can make a connection between human rights and environmental rights. I'm aware of those connections. But my point is, expressly, they don't talk about environmental rights or climate change. So this treaty could try to fill this gap. UN guiding principles, again, second example, do not expressly incorporate the principle of free, prior, and informed consent, which is very fundamental in my view, when it comes to rights of indigenous peoples who are suffering disproportionately all over the world. So this treaty should incorporate that principle as part of mandatory human rights due diligence, right? Third example is that when it comes to access to remedy, UN guiding principles cannot be the basis to provide legal assistance and mutual cooperation among the states, because you need a binding instrument for that. if state A has to collect evidence in state B, you need either a bilateral treaty or you need some kind of an international agreement, right? And UN guiding principles in itself cannot provide that basis. I'm glad we have future leaders listening, right? So I see a future hope she becomes a champion of the treaty process in the future. That's exciting. So going back to my point, so UNGPs cannot in itself provide a basis to mutual legal assistance and access to remedy. And I think that is where this treaty can fill this gap as well, in my view. So these are 3 examples I gave of an ambitious complementary relationship of the treaty with the UN guiding principles. If you look at the paper, I highlight some other elements there. So let me finally go back to my last component of the presentation, and then I'll be happy to stop and listen to debaters and other colleagues if they have any questions or disagreements or comments on what I mentioned. So how should we proceed? I think there are a number of factors and considerations we should keep in mind. First of all, we should not assume or think that this treaty will fix everything. We should also not assume that we may need only one treaty. Perhaps we need more than one treaty. With that in mind, I think we should not adopt an all or nothing approach. We should try to get this treaty, even if it is not a perfect treaty, and then continue to push for more in future. That is my suggestion. But of course, we should have certain red lines that below this is not acceptable. What are those red lines? We can debate and hopefully agree on that. But I think as long as this treaty adds value, as long as it does not merely repeat UN guiding principles, I think if it can add some value, we should be willing to accept it, even if it is an imperfect treaty, because it will move us towards binding obligations. So let me take 2 examples. Direct obligations. I personally believe that the treaty should impose direct obligations, ideally. But if it does not, I'm willing to accept a treaty which imposes obligations on states and require states to impose those obligations on companies. I'm willing to go for the indirect method as well, as long as I get the treaty. But of course, ideally, the treaty should impose direct obligations. Same applies to, can we have an international court? I think ideally we need something at the international level, ideally. Not to deal with each and every case or each and every complaint, but some complaints and some cases where you cannot get any access to remedy at the national level or at the regional level. And in many other countries, like in many other parts of the world, like European Union, Europe or Africa or the Americas, you at least have a regional system. In Asia, we don't even have a regional court, regional human rights institution. So I think there are parts of the world where there is nothing regional. Either it is national or there is nothing, because you cannot really go after companies before the International Criminal Court. You can go after corporate officials, but not against corporations, right? So I think ideally we need something at the international level. But even if we don't get it now, in my view, we can put it as part of future negotiations. We can insert a clause in the treaty that the state parties will continue to explore the possibility of establishing such mechanism in future. that is also the practice, let us say, in the Rome Statute. Additional offenses could be added, right? So I think those possibilities are there. So I think that would be my one suggestion, that we need to be a little bit realistic, what we want to achieve now, what we want to achieve in the long run and all that. The second point I would like to highlight is that we should insist of taking rights and rights holders seriously. So the treaty has to definitely convert these responsibilities into obligations. Direct or indirect is a separate question, but we cannot leave these responsibilities as responsibilities. They must be converted into obligations, even if they are indirect, and which basically means they have to be effective remedies, because without effective remedies, rights are not rights. My third point is that we should put greater focus, not just in treaty, but also beyond, to go beyond processes. I think we are putting too much focus on process. Human rights due diligence is a process. And we focus too much on the process and we forget about the outcome. The outcome is businesses should not violate human rights. How do we achieve this outcome? What do we do if this process fails? So the processes are important, but I think we should insist on outcomes. And same applies to access to remedy. We focus on access to remedy, not on remedy, actual remedy. So access to is different from actual remedy, because it could be merely a process that there is an independent court where you can go, you can fight a case for 3 years. At the end of the day, you don't get a remedy. The court was effective. You had access because of legal aid and everything, class action, right? So I think we need to put more focus on outcomes, not merely processes. And my last point is that we need to deal with the structural and systemic challenges in the business and human rights field. How do we deal with the corporate capture of the state? How do we deal with the corruption and the state business nexus? Because we are expecting governments to regulate companies, but there is not much difference between businesses and governments now in many countries. So politicians are businessmen, they are in the parliament, or they can give bribe, they give funding to political parties. And it does not matter what kind of a system, whether it is a socialist country, it's a democratic country, it's a communist country, it does not really matter. Businesses are very crucial to the governance process. They are very closely interlinked, right? So how do we ensure to deal with this corporate capture? Similar challenge, I think, is posed by the business models which are exploitative. For instance, we have a relatively new business model of gig workers, gig economy, platform workers. Can this system be ever consistent with international human rights law and labor rights law? In my view, not. This system is inherently based on exploitation. So the gig economy is presented as empowering, as flexible, better for workers. You can decide what working hours you want. But it is exploitative because you don't get any benefits as an employee. So I think we need to question these exploitative business models that keep on emerging. So earlier we had the supply chains as an exploitative model in my view, and they're continuing with us. Now we are moving towards other business models, whether these are the gig economy workers or automation. in factories, robots will come. These are exploitative business models. And I think this treaty or other international norms in the future, they should look at those inherently exploitative models. Otherwise, we will just continue to struggle to hold businesses accountable. I will stop at this. Thank you very much once again for the opportunity, and I welcome any comments, questions, and disagreements. Thank you once again for having me.
Thank you so much, Professor. It was a very enlightening presentation. You highlighted extremely relevant points in the debate on business and human rights, especially concerning the interests around the international treaty and the role of civil society. And all of these points that you've raised certainly provoke our own understanding of how this relationship between corporations and human rights should take place. I would like to thank the presence and prestige of people from around the world in this webinar to discuss this very relevant topic. We have the pleasure to have here people from maybe all of the continents. And I have some questions, but I would like to invite our debaters, Leticia and Gabriele, to present first the remarks and considerations, as well as all of our participants.
So, good morning, everyone, or good afternoon, or good evening, or wherever you are being right now. Thank you, Professor Deva. I have many questions about FARS. I would like to tell you about real cases in Brazil, just to give some color and context to violence and corporate abuse here in Brazil. There is any kind of human rights violations that you can imagine. Right? We have problems related to slavery and the textile field, for example. We have problems with child labor in the nut sector, or we have another problems, huge problems related to the environmental and social harm, especially in the mining sector. So in 2015, a dam just collapsed. This dam belongs to Samarco, which is a joint venture by BHP Billiton and Vale. And then in 2019, another dam collapsed. And now we are concerned about a third dam that may collapse. We have here Daniela, that is a specialist about this case. And we see damage and harm with no precedent, people dying. We have, you know, that's something terrifying happened there. But more recently, in the north of the country, 40,000 people just lost their homes. And you could ask me why? Why did they lose their homes? And I will need to explain you that after cracks and sinking ground near the salt mines exploited by Braskem, they just need to go away. And we have part of the city that becomes a ghost village. 4,000 people just lose their homes. You are talking about corporate behavior that causes social harm by Braskem. This is the same Braskem that is involved in a huge corruption scandal here in Brazil related to car wash operation. We are seeing terrifying stuff going on here, but our, national level, we have some guiding principles which repeat the logics of voluntary practices, and this is very imprecise and just works just on access on paper. We have here Professor Manuela Holland, who is specialist about this theme, about these problems we have with our guiding principles. And what we see that is our government is trying to, or wants to take advantage about this pandemic situation to pass or to approve bills that benefits corporations. So our scenario, we see that we rely on state, but we are seeing these limitations, like you said, about corruption, about corporate capture. We are seeing this in Brazil. And I would like to talk to you or to make some questions related to how we can reduce the regulatory dependence on the states and about direct obligations. So my first question is related to something that we as a working group started to discussing these days ago, that is about ESGs, environmental social governance. And now the cases that I bring just to give color and context to what we are talking here in Brazil, what's our situation, what's about our vulnerability here. We see that the decision pattern guided by maximizing profits for shareholders. You discussed about it in your TED talk that you gave some years ago. But now we are starting to discuss ESGs and due diligence practices that become part of the investment decisions, you know. It's a very short time, but I'd like to know, do you think that means that is a beginning of changing, of real changing, or you think that it's another way to business tell us beautiful history that is not true? You know, that's a change, or it's not, or it's just a messenger, you know, just cosmetic, you know, movement. And then it brings me to my second question that is related to controlling the business and human rights narrative. We are seeing this movement about disclosure duties and mandatory due diligence, like in European Union, France, Germany, and other countries that developed this in recent years. So you discuss about it in your article that's from business or human rights to business and human rights. That just blew my mind when I read it when I was doing my research. And you highlighted that we need proactive steps. Proactive steps needs to be taken to address this metric information, the controlling of the narrative by corporations. So I would like to hear about you how we can do this, because in sometimes I don't think it's possible, but then I start to think, no, we need to develop something that will control this narrative, or how we can assess or evaluate what corporation is doing. And then I start thinking that monitoring may help in this problem about controlling the narrative, about assessment, about evaluation of corporate practices, which brings me for my third question. Discussing about this reducing regulatory dependence on states, you mentioned about obligations to states. It's one of the points that you highlighted in the finish of your speech. About directed obligations, and thinking about how we could access this or have an external watching, I would like to hear you about how do you think that we could engineer more monitoring mechanisms, especially in regional level. You are talking about focus on outcomes, but what we are seeing right now is just procedures, but we have no ways to measure if they, you know, if they just have results, if they are working, or what company is doing. And I would like to know about this. And you mentioned it in your article about connecting the dots, that it could be a whole of CSOs in exercising and oversee over corporate behavior. And I would like to understand how you think about this in a more specific way. And then my last question is not really a question, it's something more personal. I'm doing this research about this theme only for 2 years, and you are doing this research for 20 years, you know? And for me, sometimes I was vacillating and felt hopeless, you know, that's not gonna work, it's not gonna change. And felt, no, these people, the life of these people matters, you know, we need to do something. I was vacillating between these moods while I was doing my research. And I was wondering if you felt the same way sometimes, or if you felt more hope than I do. So now I finished my participation, and again, thank you.
Thank you very much, Leticia. I'm assuming I can answer the questions now, right? Before we go to the second debater, right? Okay. So let me respond to your last point about the hope and pessimism and all this. So in fact, I feel pessimism all the time, and in fact, I am one of those who keep focusing on the empty part of the glass. There are many in the BHR field who keep on focusing on the half full glass element, and keep showing the progress we are making. And I keep highlighting that we are not really making much progress. The progress we are making is very tiny and little. It's too late and too little, because businesses keep on developing more innovative model of exploitation and abuse. So we are always lagging behind them. So we are not winning this. So I always feel pessimistic. At the same time, there is something which keeps me going. And these are the rights holders and the victims on the ground who are suffering. So when I see them, I get inspiration and the courage to keep fighting for them. So I feel pessimistic on the ground, but that pessimism also gives me power to keep fighting. So it's not that because of pessimism, I lose hope and I stop doing anything. No. So I keep fighting, I keep working through whatever I can. I hope that answers your last point. Now let me try to answer your questions. Excellent questions. I will try to be brief. Your first question is, how do we reduce the regulatory dependency on states? I think a number of things can be done. One is, when we create an international system, that is why that's how we can reduce the regulatory dependency on states. All regional and international systems we have, because we can't trust the states. Otherwise, we don't need to have international law, because states can fix everything here at the national level, right? So I think we need more regional approaches and international approaches, not as a substitute to national system, but in addition to that. When national systems fail, then those systems can be relied on. We can also rely on more non-state centric approaches. Let us say Maastricht principles. They were not drafted by states. They're drafted by academics and civil society actors and all that. And they are highly influential in terms of extraterritorial obligations of states. So my argument is, let us say hypothetically, in the worst case scenario, we don't get this treaty by the Human Rights Council. Then I would suggest we come together from all parts of the world. We draft a treaty. I think the People's Treaty Initiative has been there. I don't know what the status of the treaty is now, or the draft. I think we need to create norms. We can create some binding rules without the involvement of states, and then we bring in states whichever are willing to support that text. You know. Then your second question, or the other question, was about the recent focus on ESG, or the purpose of the corporation, and whether this is a real change. I think there is a change here, but I don't know whether this is a deep change or real change. In fact, I'm worried that businesses will capture the ESG also, and this whole idea of the purpose of the corporation may also be exploited by them. So, and I think that connects nicely with your question about corporations controlling the narrative. That's why I call that perhaps we are already moving towards not business and human rights, but business of human rights, where these consultants are advising companies to respect human rights, and these consultants and these firms are becoming perhaps part of the problem already, in my view. So we need to take back those narratives. We need to question what is happening. Even this idea of multi-stakeholder partnerships and all this, these could be narratives that can be exploited by businesses. So I think we need to be mindful of that. We should not be anti-business or anti-corporations, in my view. At least I am not. But I believe in partnerships which are principled partnerships. I don't. So I will not have partnerships which are not principled. So if they are willing to change, we can work with them to get that change done. Otherwise, I think we should not be trapped by those partnerships. I think then you also asked about the monitoring mechanism at the regional level and all this. So of course, those possibilities are there. Those things can happen because of the treaty and otherwise. But I would also suggest that we should pay greater attention to people's tribunals. Can people's tribunals be established more often and regularly at the national level, at the regional level, and international level to deal with systemic egregious violations of human rights? And we invite the company to join those because company is the defendant. And of course, it is unlikely they will join such a tribunal. But we should have independent judges, a panel of judges. We should do their fair trial process. But then we are deciding those cases without dependency on states, in my view. And I think those decisions could have powerful messages in terms of what comes out of that process, in my view. I think I will stop at this for now. Thank you.
Thank you very much. Good morning, good evening, good afternoon, all. I would like to thank Professor Deva for being here today, and all your work you've been developing is a source of inspiration for us young researchers. I have two questions, one more general and one more specific related to my field. I was contemplated by all the questions of my colleague. Thank you very much, Leticia. My first question is about the architecture of the treaty. How to avoid an influence of a political agenda and ensure that an extraterritorial regulation will not be predatory for developing economies. This is my first point. And the other things, I've been studying the pharmaceutical sector for many years, and now I'm specifically working on the counterfeit medicine in Latin America. And we see the high levels of counterfeit market and some issues related to the context of the countries here. And I would like to ask you, in such important sectors as the pharmaceutical, how to reconcile the business activities with the notion of access to medicine as a basic human need, even argued by some scholars as a human right. So how to reconcile the business activities with this notion? So we have been in Brazil, specifically cancer medicines being falsified because people doesn't have money to buy it. So desperate, they go to buy counterfeit in the last hope. So I would like to hear from you what could be done. Also, I would like to thank you for all your papers, because you write in such an accessible way for non-English speaking persons. And I would like to thank that for this accessible language. So in such an important issue. Thank you very much for that.
Thank you very much, Gabriel, and thank you for the compliment. Just as a suggestion also for anyone who wishes to write, my simple test is, if the reader cannot understand you by reading your paper once, then you as an author has failed. That's my test. So all of us should try to write in a way that the reader, whoever reads your paper, he or she can understand what you're trying to say by reading it once, rather than reading it 5 times and all this. So I think that is why I try to follow, and I'm glad that if not perfect, I'm contributing to that goal. Okay, so I think your questions are again excellent questions, and I very much appreciate those questions, because I think students like you help me think more, and I think that's why these questions are very important. Now, in terms of extraterritorial obligations, I think they're not an ideal situation. Extraterritorial obligations are problematic, but I call them necessary evil. We need them because it goes back to reducing the regulatory dependency on states. No government is perfect, but there can be situations where the government of country A is not doing something, but the government of country B is willing to do something about it, right? So if it is not driven by the politics that you mentioned, if it is not driven by some political or illegitimate goals, rather it is truly driven by the idea of promoting universal human rights, then I think extraterritorial obligations are perhaps defensible, and we have it in many other areas of law already. So they can be defended in the field of business and human rights as well. Regarding the third world countries' interest, I would suggest the burden is on the third world countries to come together and act together. The number of third world countries is more. And the first world countries, I don't like using these first world, second world, third world countries, but because you put the phrase there, my point is that in today's world, the power relationship is not unidimensional. People say China is very powerful. Yes, China is powerful. But China is powerful because every other country is doing trade with China. If no other country does any trade with China, no other country supplies any raw material to China, China is not powerful. Same applies to US or any other country. US is powerful because many countries are buying weapons from US. What I'm trying to highlight here is there is this interdependency in this today's globalized world. So if the global South can come together and they don't trigger any race to the bottom, they can definitely protect their interest much better, in my view. Same applies to the treaty process. About the pharmaceutical goods and medicines, and I think this issue has become quite critical in the context of the COVID-19 pandemic. I think patents and the intellectual property rights are important because they create incentive for businesses. But I would say these are legal rights. These are not human rights. And if there is a conflict between legal rights and human rights should prevail. So right to health should prevail over the patent rights or the intellectual property rights of a medicine company, of a pharmaceutical company. And the counterfeit medicines or goods, in many cases, are there because consumers are not able to buy the genuine goods or medicines, right? So if we can try to ensure a system where the medicines are available at an affordable price to everyone in the world, and that would also ensure that businesses which do the innovation are able to make decent profit, I think that is the way to go forward about it. That will create a win-win situation for businesses, for governments, and people. But the difficulty is where the system is opaque. So let us say the vaccine situation. So only certain companies have this intellectual property rights about the vaccines and the know-how and the technical expertise and the capacity. And even if in many cases, billions of dollars have been invested by the governments are at the mercy of these companies. So rather than creating a public good, vaccine as a public good, where all of us should be able to buy and have access to vaccines, we have a very inequitable situation. So I think that is reflective of this wider systemic problems that I was highlighting in the current model of governance and model of doing business in the world. I don't think this treaty will fix everything. That's why I also want you to not have too much expectations from this treaty, even if we get one. But we need to keep on working on something else. This is an ongoing battle. So this is like a marathon. This is not a 100-meter sprint. Human rights is a marathon. So we need to keep fighting for many, many years to come. And the challenges will change, but we need to keep fighting. I don't think human rights will ever be safe. Thank you.
Well, thank you, Professor, for the presentation and the answers. I would like to ask you if you had time for a few more questions. I mean, I have one myself, I think João and Victoria, and also Professor Manuela has their hands up. So could we do 1 or 2 rounds of quick questions? Would that be okay?
Yes, I think let us collect some questions and I will try to answer them quickly. Yes, let us do that. Thank you.
So I'll put a question quickly, which relates a bit to Leticia's previous question on ESG, but it's a bit different in a point, which is, it relates a lot to your latest article in the annual review of law and social science about the alternative approaches to transnational regulation. And one of my concerns is the one that you pointed out and also pointed by Professor Anita and Zastri before, which is BHR risking becoming a new CSR or a new ESG, which is already also almost like a new CSR in my opinion. And that we need regulatory approaches that are concerned with the right holder and not concerned with what business asset, basically. And this is what my concern regarding this point is the response usually is we need a shift, right? In the way we think, in the way corporations behave, in the way we regulate. The shift in the meaning that what matters is how do we actually do something and not what can be acceptable for a corporation, not in the international sphere, but I'm talking about the business itself. And I think one of the answers you already pointed it in the beginning of this lecture, which is the rights holder have to be on the center of our approaches. And my question is how do we put the rights holders in the center of the regulation of business? What could be an approach for that, and how would that be manageable? Because what I've been seeing, at least here in Brazil, I've seen in the Samarco case that Leticia also mentioned, we tried to put a rights holder approach to and Professor Manuel also knows about it a lot, I guess, to the reparation of the case. It's not even prior actually to the access to remedy, and it didn't really work. And it had to go to courts again, and it's still a very long, ongoing process of trying to get something in the courts. So my question is basically, how do we promote this shift in the way the regulation that we need to have rights holders in the center, and how can we do this basically in practice? And I'll pass on to the next questions then, so we can do this more quickly. Maybe João.
Thank you very much, Professor, for your brilliant presentation. I want to address a quick question as well. And that is regarding the process you talked about, which is related to the trigger effect that the UN guiding principles make regarding national legislation. As we can see when we analyze the new German Supply Chain Act, for example, the UK Modern Slavery Act, and other pieces of legislation as well. They all have the mandatory human rights due diligence perspective as a common requirement of the legislation. And what I would like to question is the due diligence obligations could increase the production costs, something that could be affordable for big players, but that could undermine small and medium-sized players which need to comply with these requirements that could be imposed, including from the big players' perspective. And these small and medium-sized players are usually more sustainable, more compliant with legislations, more environmentally friendly. And when we see even the Brazilian perspective as well. What are your thoughts on this perspective, and which action or provision could we envision to avoid this from happening? So thank you very much again.
Sure, if I may, just before you answer, I think my question is complementary with the two previous. So my question is related to enforcement. So the treaty is one initiative to enforce obligations, but in our view, specifically when we look at the experience with COVID-19 pandemic in the world, we can see now discussions that can be raised concerning ESG, like Leticia raised. And this seems to be a point of no return concerning the assessment of corporate behavior. But my point is, if in your view, these initiatives like the international treaty are really the best way to promote the corporate ethical behavior. I mean, how do we interpret the challenge of fostering and encouraging corporate behavior towards human rights and the environment? Thank you so much.
I think Manuela also has her hand up, so I don't know if she wants to add her question or the second round.
I don't know, Professor, if you are available for another question, or may I wait for the answers?
I will try to answer all together. Yeah, ask your question now.
Okay. Yes, Professor Deva, most of all, I would like to thank you for your contributions. You have been my professor, because I've been studying this just for 10 years, and I learned almost of what I know with you. So thank you very much again. And I'd like to make a question about the working group. Okay, because as you've said, okay, there is a need of a more, how can I say, a complementary discussion between the treaty and the guiding principles, but an advanced one, that would really discuss filling the gaps of the guiding principle, which has not been the case in most of the countries' position in the negotiation. They just want to make guiding principle liable, or no, or obligatory. So I would like to ask you if the position of the working group could be more, how can I say, more precise in relation to it, because even in our countries, what we've been seeing is that the countries are repeating this narrative that, okay, we're going to do a national plan, just making guiding principle liable, okay, obligatory, not filling the gaps, not advancing, not going beyond the guiding principle, as you have said. So because here in Brazil now we are starting to maybe negotiating a national plan, but we from the civil society and other academic groups that have been working on it, having been defending a legislation, a national legislation, but we're avoiding calling this a national plan, because we know from research that the national plan are not going beyond the guiding principles. That's why we are not against the national plan, but we are afraid of that the national plan just repeat the gaps, not filling this, not going beyond the guiding principles. And the countries are mainly using this narrative just to make guiding principles obligatory and not going beyond. And we are almost defending a national legislation, not calling this a national plan, but really defending going beyond the guiding principles, as we have said. So I'd like to ask if the working group could make a more clearly narrative, or discuss in relation to it, because maybe the message to the country is not so clear in relation to it. as working group, because I've been in other spaces with the working group on business and human rights, and I don't know if it's so clear as you have said now. So thank you very much. It could help a lot for our work at the national level if it would be more clear.
Thank you, Manuela, and thank you all of you for again these very good questions. So I will try to answer all the 4 questions, but perhaps let me start in the reverse order and start with Manuela's question first and go to all the questions. I think working group is a group, and I think that makes it complicated in terms of decision-making process to take a position for the working group. If working group was just me, let us say hypothetically for 1 minute, I could issue a statement today, what I've said. But in practice, it is a complicated process. And I think there are some subtle shifts in the position of the working group. It will also depend upon who the members of the working group are at a given point of time. So let us say how things change, but your point is well taken, and I hope the working group does that, what you mentioned, because I think that is the way forward in my personal view. So I think I agree with you as a matter of principle, but I cannot control how the working group will operate, right? Because it is a group of 5 members, and they have different views, different preferences, and there is a history to the working group, and so I think that makes things very, very complex. I think there was a question whether this treaty is the best way. I think there is no best way. There is nothing is a best way in regulating businesses. Treaty is not the best. UNGP is not the best. Nothing is the best because there is hardly anything which is perfect. I have already highlighted that. We already have different pieces of hope, pieces of inspiration. So my suggestion is try to make best use of everything that is possible. And we keep on adding more tools as per the needs of the time. I think that should be the flexible approach and innovative approach that we should keep in mind. Then there was a question about mandatory human rights due diligence and the cost of compliance, especially for small and medium-sized enterprises. I think that is a real issue. It may be unaffordable for them, and that's why I personally believe that mandatory human rights due diligence, the government should encourage all businesses to do due diligence, encourage all to do it, but mandate only some to do it. And that some could be big companies, or it could be all companies operating in a risky sector, or all companies operating in a conflict situation, right? So I think it depends upon the size of the company or the nature of the risk that you are posing to the people, or the setting in which you are operating. So in my view, it should be mandatory based on these factors. So rather than mandatory for each and every company, because that is impractical in my view. At the same time, I also believe that we need to provide incentives to companies, whether these are small companies or big companies. So the companies which are seriously willing to respect human rights, we need to give them tax rebates, easier access to finance. Consumers should be willing to support and buy their products and services. So we need to create. So I am very critical of the business case because there is no business case, and we should not link human rights to the business case in my view. At the same time, I think regulations have a role to play to create a market for human rights. And we create a market for respecting human rights if we change the current dynamics in terms of cost and benefit. Now, businesses see more benefit from abusing human rights. We should make abusing human rights a costly business. Once it is a costly business, then perhaps businesses, not all of them, but many of them will start realizing it. So I think that is my response to that. How do we do a shift? That's the last question. Or perhaps that was the first question, but I'm answering it the last because that is the big question. How do we bring a shift? How do we put the rights holders at the center, right? So some ideas on this. First of all, we need to change everything, how we conceive the very idea of development. Now, what is development? Development is that the ministers of a government sit in a 5-star hotel with some top executives and they decide what development this country wants. This is a top-down model of development where selected elites, selected powerful people, whether politicians or business people, they decide what is development and what projects we want in this country. Then the impact assessment or due diligence is just a tick box exercise because the project has already been decided in the 5-star hotel that we want this. Nothing changes on the ground then. So I think we need to question and change this top-down model of development. This is the shift I would like to see. Bottom-up model of development. Let the people in a village decide what they want. If they don't want a coal power plant, if they don't want a hydropower project, if they don't want a mining project to go ahead, that should be the period. That should be the end of that project because they don't want it. Because the reality is those people who suffer, they don't benefit from this development. That is the reality. And that is a reality not in Brazil, not in Latin America. That is a reality all over the world. I remember in my own country, India, I went to a project 5-6 years back. So it was a very big coal power electricity plant, about 1000 megawatt. So I was standing on a road. On my left-hand side was a big power plant. On the right-hand side were some farmers on whose land the plant was built. So these farmers did not have electricity in their huts. So an electricity plant that is built on the land of the farmers is not supplying electricity to these farmers. How can more paradoxical it can be? So the development, so we need to bring this kind of a shift. How do we do it? How do we bring it? I think one thing that I would like to suggest is that we need to recover the state. And that's why business and human rights should be part of the political process, in my view, at every level of elections, at universities, in towns, in villages, in provinces, at the central level. Because we do not have the political will to uphold human rights, right? So we need to build that will, the political will. We need to select and elect only those politicians and people in power who are willing to support that agenda. Ultimately, we have rights. So we need to claim those rights and use our power collectively to change this discourse, in my view. So I think if people come together, they can definitely do many more things. But we need to move away from our myopic interests. We need to look at our larger interest in a society at the national level or at the global level. I think those are the things that we need to consider. Thank you very much. I hope I answered all the questions that were asked. I know there are questions in the chat box as well, but I'm running out of time. Feel free to send me an email. If I find time, I'll try to answer. But thank you once again for the opportunity. It was a wonderful experience for me, and I wish all of you good luck because we need more of you. As I keep telling that the role of a teacher is not merely to do good things. The role of a teacher is also to inspire, to create more of like us. So I believe all of you will multiply and become more of like us, and we are part of the change collectively. Thank you very much once again.
Thank you so much, Professor. The very high level debate certainly raised a lot of questions, even here in the chat. So if we may, we can address them later by mail if it's okay. And I would like to thank you for raising so many challenging questions that certainly will improve our understanding of the relationship between corporations and human rights. It was a really great and inspiring discussion that raises us important questions on this topic. And in the name of the Business and Human Rights Working Group, we thank you so much for the presentation and for your time. And I want to thank our debaters, True, Leticia and Gabriele, my colleagues, all of our participants from Brazil, from Roma Center of Business and Human Rights, and to all of the people around the world that joined us in this webinar. I just want to mention that we have a series of webinars going on, and we look forward to have all of you there too. Thank you so much, Surya.
Thank you, Victoria, and thank you, everyone. Bye-bye. Take care and stay safe and remain connected. Bye for now.
Thank you.
Bye-bye. Thank you. Bye-bye.
Thank you. Bye-bye.
Bye-bye.